We're going to explore a very important topic in estate planning, especially what assets should not be placed in an RLT or revocable living trust here in Arkansas. Now, these trusts can be very powerful tools. They allow individuals to avoid probate. It allows you to maintain privacy and have a smooth transfer of assets after you die. However, not every asset belongs inside this type of trust. In fact, placing the wrong assets in an RLT can create unnecessary complications. It could duplicate efforts, even have unintended legal and tax consequences. My name is Leon Jones Jr., and I've been practicing law in all courts in Arkansas, as well as corporate law and state government for over 15 years. Now, I'm the managing attorney here at Big Rock Legacy Law Group, where we help our clients with estate planning, business law, family law, and litigation issues. Today, I'm going to focus on 5 categories of assets that generally should not be placed in your RLT here in Arkansas. Now, these include vehicles, life insurance, annuities, retirement accounts, and jointly held property. Properties such as survivorship right property, like your primary residence. Now, I'll also try to provide you with some practical insights into why alternative planning methods may be more effective for these assets. So let's start with your vehicles. Many people wonder, should I put my boat or my car, my RV into my RLT? Well, here in Arkansas, the short answer is no, and I'll tell you why. Vehicles are generally not subject to probate in Arkansas the same way that real estate or financial accounts may be. The Department of Motor Vehicles provides for a streamlined process for transferring your vehicle titles after you die. In most states like Arkansas, this process is much simpler than retitling every vehicle into your trust during your lifetime. Next, vehicles depreciate in value, and they often change hands. Constantly updating your trust to reflect the changes adds unnecessary complexity. Arkansas law already provides for a simplified probate process for smaller estates. And under the small estate, if it's valued less than $100,000, it excludes your homestead and exempt property. And it's more streamlined, which includes your vehicles. So for these reasons, it makes far more sense to allow for vehicles, boats, and RVs to pass outside of your trust through a simple title transfer or small estate affidavit. Let us here at Big Rock Legacy Law Group assist you with this process. Click the link below, schedule a call, and let's get started today. So now let's talk about life insurance policies. Life insurance is designed to pay out directly to a named beneficiary. And under Arkansas law, when you designate a beneficiary on a life insurance policy, those proceeds bypass probate entirely, meaning they're not governed by your will or your trust. Instead, the insurance company pays the person you designate directly as your beneficiary. So by placing an insurance policy into a trust, you can risk creating confusion or delay. It's preferable to rely on beneficiary designations, which provide a clean and direct transfer. While trusts are effective vehicles and tools, they're often unnecessary when a beneficiary designation already achieves the same goal, which is to avoid probate. So keep your life insurance beneficiary designated up to date and current, and have it aligned with your estate plan. So that way it'll accomplish everything your trust needs to accomplish with less complexity. Annuities are very similar to life insurance in this respect. They also pass directly to the named beneficiary. If you attempt to retitle the annuity into the name of the trust, it may trigger unintended tax consequences or penalties, depending on the terms of that contract. So to make it cleaner and more efficient, it's to just designate the trust as a contingent beneficiary if it's appropriate. That way, if the primary beneficiary, say your children, pass away before you, then the proceeds can flow into the trust. But retitling the annuity into the trust is generally unnecessary, and I wouldn't advise it. So let's talk about now retirement accounts, 401ks, IRAs, or other qualified plans. It's never advisable almost to transfer those directly into your RLT. It could trigger immediate tax consequences because those are generally tax deferred while in your name. Transferring the ownership to a trust would be treated as a distribution, creating a huge and unnecessary tax bill. Arkansas law and federal law allow you to use beneficiary designations on these as well. So name an individual and as your beneficiary, and this will ensure that your assets pass directly without probate. It's favorable from a tax perspective as well. This is a critical distinction. Using beneficiary designations protects both the tax-deferred status on the account and the efficient transfer of the account. So now we can take a look at jointly owned property. In Arkansas, that's property that's held as joint tenants with the right of survivorship, and it passes automatically to the survivor upon the death. In addition, Arkansas also recognizes a form of ownership called tenancy by the entirety for married couples. This functions much like joint tenancy, but provides for additional protections. Because of this, there's no need to place the jointly held property into a trust. The law already ensures the smooth transfer of ownership without the need for probate. There are some exceptions, of course, and some special cases that we need to be aware of. So here they are. Non-probate assets can become probate assets if no beneficiary is named or if a beneficiary predeceases you. So for example, if you forget to update your life insurance after the divorce or after the death of a named beneficiary, that policy could fall into probate. Also, creditors may still attach certain non-probate assets to claims. Just because something bypasses probate doesn't mean it's completely shielded from legitimate debts. So you have to regularly review your estate plan and don't just set it up and forget it. Life happens: marriages, divorces, deaths, births. So these should prompt you to review your beneficiary designation and your estate plan. The purpose of estate plan is to create clarity and efficiency and peace of mind. So by understanding how Arkansas law treats these different assets, you can avoid unnecessary complications and ensure that your wishes are carried out smoothly. I encourage you to review your estate plan regularly, at least every 24 months, and consult with qualified professionals. And remember that a revocable living trust or an RLT is a valuable tool, but it's not the answer for every type of asset. Make sure you subscribe to our channel to learn more about how we help our clients every day here at Big Rock Legacy Law.